So we're seeing they're exchanging car for another car. And then on top, 250 pounds was added. So the question was whether this particular transaction was of barter or sale of good. So the transaction, the holding of the court was that this transaction was barter because monetary value was not affixed to that particular transaction. The motor vehicles, no monetary value was affixed to them. So that particular transaction the court held was a barter. In another case, Aldrich vs. Johnson, there were two parties, they were exchanging now 50 bullocks valued at 192 pounds. On top of it, they were also adding 23 pounds, 400 quarters of barley valued at 215 pounds. So there, barley and the bullocks, monetary value were fixed. So in this case, the court held that transaction was a sale of good and not barter. And the only distinction was now consideration. So you'll find the major consideration between sale of good and barter is basically consideration. One is in form of money, and the other one is not in form of money, is in form of good or services. So we are saying now a sale of good contract must involve consideration as well as meet all the criteria for valid contract. We know a valid contract has essential requirements that include an agreement, that is offer and acceptance, consideration, intention to create legal relation, capacity, certainty, and legality of the contract. In conclusion, barter is a contract where goods are exchanged for goods and where consideration is anything but money. It is a valid contract, but it's not a sale of good because it does not entail money. So basically, even in Kenya right now, government discourages barter because it's construed to undermine money because of also issue of taxation. Because if now goods are exchanged for other goods, you know, taxation is very critical for government in provision of services. So how do you tax that kind of transaction? So as we speak, government encourages monetary transaction and not barter transaction. In fact, of underground business, government doesn't discourage it. That's the end of my presentation. I yield the floor to the next presenter. Thank you.
Thank you, Mohammed. My name is Brenda. I will take you through the distinction between sale of goods contracts and contract of gifts. Now, according to the Black's Law Dictionary, it defines a gift as a voluntary transfer of goods or conveyance of land from one person to another without any consideration. But on the other hand, under a sale of goods contract, consideration in form of money is a requirement in accordance with Section 3(1) of the Sale of Goods Act. Another distinction is that a sale of good contract satisfies all the elements of a valid contract and is therefore legally enforceable. But for the contract of gifts, it is not legally binding. And in such contracts, it can be made legally enforceable by the seal of a deed. Another major distinction that in Section 2(1) of the Sale of Goods Act, goods do not include money, things or chores in action, or crops or fixtures, or land and any other immovable property. However, in contract of gifts, it may entail all these items which are excluded from sale of goods of contract. In the case of Esso Petroleum versus Customs and Excise, Esso ran a promotion of giving free coins to anyone who purchased 4 gallons of petrol. The Customs Department demanded taxes from the coins. However, Esso argued that the coins were free gifts. So the argument was whether this transaction was a sale of goods or gifts. And the court held that the coins were not exchanged for a money consideration, and therefore the transaction was not a sale of goods contract. I'll hand over the mantle to my next colleague. Thank you.
Good morning. My name is Boaz Odhiambo, and I'm going to present the sales of goods contract, the difference between the sales of goods contract and the contract of bailment. And first of all, the major difference as the slide is being presented is that bailment is defined as the transfer of possession upon trust from the bailer to the bailee on a contract until the time, use or purpose for which they were bailed has elapsed or has been performed or accomplished. A sale of goods contract is different from the contract of bailment in the following ways. One is the distinction of consideration, where according to Section 3(1) of the Sales of Goods Act, the property in goods is transferred to the buyer for money consideration called a price. This is, however, not the case in bailment, which is not necessary to prove a consideration. The second point is that another distinction is in ownership, that is the passage of title. In a contract of sale of goods, the seller transfers or agrees to transfer the ownership to the buyer, whereas in a contract of bailment, it is the possession of goods which is transferred and not the ownership. Physical delivery of the goods is made to the bailee, but ultimately they must be restored on the accomplishment of the purpose for which the bailee holds them. Another distinction is the passing of the property in goods. In a contract of sale of goods, the property in goods passes to the buyer. However, in a contract of bailment, there is no intention that the property in ownership is to pass from the bailer to the bailee, and it does not pass on delivery of the goods. The bailee only has the custody to take care of the goods for small fees. The bailee is only empowered to sell the goods for the purpose of recouping the demurrages. In some cases, however, the intention of the parties is that the property in ownership should pass in due course, as in the case of the ordinary hire purchase contract. But where goods are delivered to another person on terms which indicate that the property is to pass at once, the contract becomes one of sale and not of bailment. We have an example in Chapman Brothers versus Vasco Brothers. This case is about farmers who delivered bags of wheat to a company who are millers, and the agreement was that the millers were in due time, upon the instructions of the farmers or requests of the farmers, to purchase the wheat. However, the wheat and the bags of the wheat were similar, and what happened is that the court, Ibrahim, please, the slide, as I continue presenting. The terms of the transaction require that the company to buy and pay the wheat on request by the farmers, or on failing such a request on a specified day, to return an equal quantity of the wheat of the same type. But there was no obligation to return the identical bags. Now, the question that the court had was whether it involved the sale of goods. Although the contract referred to the company as stores, it was held by the Australian High Court that this transaction was necessarily one of sale of goods, as the property passed to the company on delivery. The court pointed out that in a sale of goods transaction, property passes even if not at once. This was the nature of the transaction, and therefore it seemed inconsistent with the possibility of a bailment. The ruling out of the transaction as an agreement of sale within Section 2(1) of the Sales of Goods distinguishes a sale of goods contract from a bailment contract in terms of passing of the property in goods. So in conclusion, I'll say that the main distinction between bailment and sale of goods is that the passage of the title from the seller to the buyer. In sales of goods, the title passes from the seller to the buyer, while in bailment, there is no transfer of title from the bailer to the bailee, but there is only the delivery of goods. I will allow the next presenter to take over.
Good morning. My name is Kalecha. I'll be presenting the difference of hire purchase and contract of sale of goods. Okay. A contract of hire purchase is defined as a contract where the owner of the goods hires them out to another person who pays periodic installments as agreed upon by the parties and gives him the options of purchase. The options may or may not be exercised, may or may not be exercised. The goods remain on bailment of hire only, and the property in them does not pass to the hire unless and until all the agreed hire purchase installments have been paid and the options to purchase duly exercised. A sale of good contract is different from a contract of hire purchase in the following ways. One distinction is that credit terms, where under the sale of good contracts, the ownership of the goods passes to the buyer immediately the contract is made, in which case the buyer can subsequently pass a good title to another purchaser even though he has not paid the full price. However, under contract of hire purchase, the goods remain on the bailment of hire only, and the property in them does not pass to the hire, and he consequently cannot pass the title to another purchaser unless and until all the agreed hire purchase installments have been paid and the options of purchase duly exercised. Before the options of purchase is exercised, the goods under the possession of the buyer are held under bailment. Such goods cannot be seized under the judicial execution, sold to another party, and detained. Similarly, in the event the hire is adjudged bankrupt, the goods under bailment are protected against claims by creditors, unlike other goods in possession of the hire, which are distributed to the creditors. In a hire purchase contract, the client is given the options to either purchase the goods, while in sales of contract, the buyer has no options of hiring the goods. In a hire purchase contract, the hire pays periodic installments as agreed upon by the parties, whereas in a sale of goods contract, a lump sum amount is paid. In a hire purchase contract, the hire takes possession of the goods at the beginning, but is only entitled to ownership upon full payment of the hire purchase price, whereas in a sale of goods contract, title passes to the buyer immediately. A contract of hire purchase is regulated by the Hire Purchase Act, while a contract of sale of goods is subject to the Sales of Goods Act. In a hire purchase contract, the client is given the options to either hire or purchase the goods, while in a sale of contract, the buyer has no options of hiring the goods. In a hire purchase contract, the hire pays periodic installments as agreed upon by the parties, whereas in a sale of good contract, a lump sum amount is paid. In a hire purchase contract, the hire takes possession of the goods at the beginning, but is only entitled to ownership upon full payment of the hire purchase price, whereas in a sales of good contract, title passes to the buyer immediately. A contract of hire purchase, I've repeated. A contract of hire purchase has to be registered in the Registrar of Hire Purchase Agreements within 30 days after making the contract and the certificate of registration issued, but this is not the case for a contract of sale good, which only involves the parties. In a hire purchase contract, goods can be repossessed the failure to pay less than 2/3 of the total amount, but in a sale of good contract, the seller cannot repossess the goods upon the hires failure to pay any of the amount. He can only sue for breach of contractual agreement. This is the end of my presentation. I yield the floor to the next presenter.
Good morning. I'm going to talk about the distinction between a contract of sale of goods and a contract on loan on security of goods. A loan on security of goods is a transaction that is designed to enable A, who owns some goods, to borrow money from B and give possession of those goods to the money lender. The goods can only be reclaimed upon completion of repaying the loan. So we have A. A needs some money from B. A has some goods. Probably, let's give an example of a car, but he needs to borrow money from B. So he gets the money from B, but leaves the car with B for a while until he's able to repay the money. Once he repays the money, he gets his car back from B. This transaction, the contract on loan of security of goods, doesn't mean that the person borrowing the money has transferred the property in the goods to the money lender. He only delivers the goods to the money lender to hold as security. He has not sold the goods, but he has only given it to him to operate as security. The understanding is that A will retain the possession of the goods and the borrower will repay the lender B capital plus the agreed interest, and eventually the borrower will have the right to take back the goods if he has repaid all the claims by the lender to him. So the lender has no right to resell the goods unless the borrower has defaulted. This is different from a contract of sale of goods, which enables someone to acquire goods on payment of a price. Loan of security is just to enable someone to borrow money as he gives his goods as security of the goods. But once he's repaid the money, he gets the goods back. I yield the floor to the next presenter.
Yes, next presenter.
Good morning, everyone. My name is Ronald, and I'm going to try to bring out the distinction between sale of goods contract and the contract of agency. Contract of agency arises in a contractual agreement when one person, called an agent, is authorized or appointed to act as a representative of another person, called the principal. A contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration, called the price. Section 2, subsection 1 of the sales of goods contract defines Section 2, subsection 1 defines a seller as a person who sells or agrees to sell goods. There, a seller may include an agent acting on behalf of his principal. Some of the distinctive features between the two also include the following: that agency involves a relationship between an agent, a principal, and a third party in which the agent acts on behalf of the principal. In sale of goods, the buyer or seller can act on his own or maybe through an agent. In sale of goods, the title passes from the seller to the buyer, while in agency, title passes from third party to the principal. In sales of goods contract, the buyer or seller may sue the other party for breach of contractual agreement, while in agency, the principal and third party are liable to each other. In a contract of sale of goods, the buyer pays the price for an object, whereas in a contract of agency, the agent is not obliged to pay for price. He is merely obliged to deliver the price received from buyer. Another distinction is that in a contract of sale of goods, the buyer becomes the owner of the thing, whereas in a contract of agency, the principal remains the owner even if the object was delivered to him. Further, in a contract of sale of goods, the seller gains profit, whereas in a contract of agency, the agent is not allowed to make profit. The distinctions between sales of goods contract and the contract of agency is sometimes difficult. For example, when A asks B, a commercial agent, to obtain goods for him from a supplier or from any other source, and B complies by sending the goods to A, it may well be a fine point whether this is a contract under which B sells the goods to A or is a contract under which B acts as A's agent to obtain the required goods from other sources. In an agency contract, there may be privity of contract between the buyer and the agent supplier, which will enable action to be brought between them. On the other hand, if it's a sale, there will be no privity between the buyer and the seller's own supplier. The duties of a commission agent are less stringent than those of a seller, and in the event of a breach of contract, the measure of damages may also be different. Thus, if a seller delivers less than he is bound to under the contract, the buyer can reject the whole. But if, despite his best endeavors, a commission agent delivers less than his principal has ordered, he has committed no breach of contract, and the principal is bound to accept whatever is delivered. Should the commission agent deliver goods of the wrong quality, he will only have to pay as damages the actual loss suffered by the buyer. but should a seller be guilty of such a breach, he may have to pay damages for the buyer's probable loss of profit because the contract is not of sale of goods. Thank you. I yield the floor to the next presenter.
Good morning. My name is Franklin Makanga. I'll be handling this difference between the sale of goods contract and intellectual property, that is copyrights, patents, trademarks, etc. Intellectual property includes patents, trademarks, copyrights, registered and unregistered design rights. The main distinction between sale of goods contract and contract of licenses of intellectual property is the subject matter, in which under the sale of goods, the property is tangible goods which are movable, while under the intellectual property, the subject matter is intangible. Therefore, intellectual property items are not included within the meaning of goods under the Sale of Goods Act. The other outstanding distinction is under sale of goods contract, the seller transfers the property in goods to the buyer for a money consideration, while under the contract of licenses of intellectual property, the transaction is subject to copyright restriction, which include the return of the software in case a software user violates the agreement, requirement of periodic fees instead of a once-off fee. Further, sale of goods contract entails transfer of property in the goods, while contract of licenses of intellectual property, the title to the software remains with the third party which had developed it. Items of intellectual property such as copyrights, patents, and trademarks are not personal chattels or corporeal movables, and so fall outside the definition of goods, although goods may exist which embody these intellectual property rights. In modern times, an important point not yet wholly resolved is whether computer software may constitute goods within the meaning of the Act. Software is normally embedded in some physical form, such as disks, or as part of a package in which it is sold along with the computer hardware. That is computer or computer parts. It is protected as a literary work by the law of copyright. Usually only the medium in which the software is embedded, e.g. a disk, is sold. The copyright in the software remains in the software house which developed it. The software house licenses the user to make working copies of the disks and to load the software into a computer. Acts which otherwise would be infringements of copyright. Software can also, of course, be delivered online subject to licensing terms. So we have come to the end of our presentation, and thank you so much. Have a good day.
Any questions from the class? Thank you for an excellent presentation. Members of the class, questions? Questions directed to the group? When we talk about advertisement via internet, which is quite often in modern day, what would you term that advertisement? Is it an offer or an invitation to treat? The last presenter.
I think he's logged out. So may I take up the question? And
Yes. Anyone can do.
On behalf of the group, I think it is an invitation to treat. An advertisement would qualify as an invitation to treat since it invites a prospective buyer to make an offer.
Thank you. I agree. If a company has placed an advertisement of selling, for example, an Apple iPad at shillings 100 via an email, and then you accept, are you making an offer or you are accepting the offer?
Come again, please.
If, for example, a company has placed an advertisement of selling an Apple iPad at, let's say, shillings 100, and you order the same via email, are you accepting an offer or you are making an offer? Anyone?
I think in this case, if they have addressed it to the world, and you're actually basically accepting that offer. They are making an offer, and then you're accepting. So then they are obligated to sell to you. I would say so. Thank you.
Wanjiro, do you agree? Wanjiro, I had seen your hand up. Do you agree?
Yes, I do. I think it's accepting. It's not making an offer, it's accepting it.
Sure. Are you really accepting an offer?
Yes. Isn't this
Which
the same
offer?
as the smoke wall scenario?
You have just been told, and we have mutually agreed that advertisements which are made via an email constitute invitation to trade. Consequently, if you send an email accepting that invitation to trade, you are actually making an offer. It is for the advertiser to accept your offer or reject. All right?
Yes.
Correct? Mohammed, understood?
Yes, yes. Can you come back again? Clarify, please. So that it sinks.
We have said first, advertisements via internet do not constitute an offer, but they are, in fact, invitation to trade. Therefore, if you respond to such an advertisement, say, for example, we take an advertisement of a company selling an Apple iPad for only 100 shillings. If you send an email in response there to saying, I hereby make an order of 100 pieces of the Apple iPad, you are making an offer, you are not accepting an offer. Because the advertisement from the Apple company is merely an invitation to trade. All right?
Yes, yes, true.
Supposing there was an apparent error in the price quoted. For example, in the same example I'm giving, an Apple iPad cannot cost 100 shillings. Supposing the advertiser intended to mean 100,000 and to make an order before the advertisement is corrected. Is the company obligated to supply you with the iPad or with the order?
No, it's not.
It's not.
Yes.
Thank you. Clear. Okay. Another intervention. Let's look at sales of hardware or software. This software, you can download software in a soft medium via the computer, maybe from Google. If you happen to download that software for your own use, does the software constitute a good, or it constitutes protected intellectual property? Yes. That from the last presenter. Yes, if you download software, let's say from Google or Chrome, does that software constitute a good within the meaning of the Sale of Goods Act?
Well, can I try?
Yes, yes.
I think from my own understanding, Sale of Goods is something that's tangible and also movable. So in this case, we're talking about an item of, it's kind of intangible. It's not a tangible product. So I would say,
I would like to assist.
Yes.
Ibrahim, can I assist you, please?
Yes, yes, please.
Thomas, go ahead, please.
I am quoting from the preamble of the Sale of Goods Act, which defines goods as including all chattels, personal, other than things in action and money, and all implements, industrial growing crops and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. As we have seen in our last presenter, software is often sold as software is installed. It is an item of copyright. It is not really a good. It is an item of copyright rather than a goods. Therefore, within the meaning of the Sale of Goods Act, from the preamble, the definition of goods, software does not qualify as a good.
Supposing the software is contained in a tangible item, which is actually permanent, like a disk, would you hold the same position? Yes.
Can I try again?
Yes, yes, please.
I think from our reading, I think these are some questions that have not been resolved as whether it actually qualifies to be good because of that element of tangibility or not. So these are questions that have not been fully agreed upon. So there's a bit of lacuna in that part. That's from what I came across from my readings.
Anyone else who would like to try?
I would like to add.
Yes, please.
I would like to affirm Mohammed's point.
There's a lacuna. You're affirming
okay,
that
this
there's a
position.
lacuna.
This position or this issue of whether software embedded as part of hardware is part of its product is a point that is not yet resolved. This is a challenge of the modern times, as has been indicated in part of our presentation. Software is considered an object of copyright within the meaning of goods, or within the definition of goods as per the Sale of Goods Act. Software does not constitute part or cannot be quantified or qualified as the definition of goods. Therefore, this point really remains contested and is not resolved.
Perhaps you may take down the following remarks. In respect of computer software, you may take note of the following. If downloaded and not in a tangible form, then it is not a good, but if contained in a permanent medium, such as a disk, then it is a good, just like a book. You may wish to read the case of St. Albans, DC, versus ICL, 1996, Volume 4, OER 481. Volume 4, OER 481. Read that case.
That's well noted, sir. Thank you.
If software is provided as a license to use, then property remains with the owner, and so there is no contract of sale of goods. Read a recent case of Southwark LBC versus IBM UK Limited, (2011), EWHC 549. It's an English case. Let's go back to contracts for labor and materials. And I wish to ask, you give an example of a painter who was contracted to do some painting job. And you said that amounts to a contract for supply of labor. What if I go to the shop and I buy a duly painted object? Would that one also be a contract of supply of labor?
I suppose that would be a contract of sale.
So if I was to buy a completely finished painting, then I am actually buying a tangible item of which the painter has already completed his input into it. That is a sale of goods contract. Let me ask you, supposing I have bought a new Mercedes-Benz here, and there is no spare parts available, and I order spare parts from a Mercedes manufacturing company with special specifications, which means they will have to make afresh the spares required to fit in my specifications. Does my order qualify to be a sale of goods contract, or is it one of sale of labor?
May I attempt?
Yes, yes, please.
I think it will be that one of labor, because you've given specifications, you've given instructions on how they're supposed to manufacture it, or you've told them to make that engine in a certain manner that is separate or different from what they have already produced. If it was a sale of good, it's an already made product that you go and purchase it from the manufacturer.
Do the others agree? Any contrary opinion? Any contrary opinion? Feel free to exchange. Share your ideas. Feel free. Any contrary opinion? You agree that it's a contract of supply of labor, but not a sale of goods contract?
Sorry, my internet has been having problems, but if I may,
Sorry, please
I may
try.
contribute. So
Yes.
we are still talking about the painting. Just so I'm clear.
Not really about the painting, but you can make your comment about the painting, then I will tell you where we are now.
Okay. So for me, about the painting, if the painting has already been done and you see the painting and you buy it, then that is a contract for sale of goods. But if the painting is yet to be done and you request for a painting to be done for you, then that is a contract for labor, for services. So it depends on whether or not the good has already been done.
Thank you for that. Okay, I was asking, let me ask a different, from a different perspective. If I own a ship and ask for propellers to be supplied according to a specific, according to my own specifications, would that one amount to a contract of supply of labor and materials, or it is a sale of goods contract?
Can I try?
Yes, please.
You are making an order, and ultimately what comes is a good that conforms to your requirement. So the question is this good tangible? And in which case, when you refer to sale of good act, there are two words that are defined. One is goods and then future goods. So I would say it's actually a good, but a future good. That's what I would say. So it's actually a good, not contract for labor. Thank you.
Thank you. Thank you. Yes, Mike.
Good morning. I think
Morning.
we'll we'll cover this in the next group's presentation. But for me, I think it's all about was the good in a deliverable state. If it was not in a deliverable state, then it all falls under a sale of goods contract. Thank you.
Thank you. We have said that contracts for labor and materials are distinguished from sale of goods contract by looking at the hallmark or the core purpose of the transaction. In a sale of goods contract, the transfer of ownership to the buyer should be the main object of the agreement. If the main purpose is something else, for example, the provision of labor, then the agreement is not a contract of sale under the Sale of Goods Act. This is so regardless of the fact that an incidental or ancillary object of the contract is the transfer of ownership in some goods. And that is what the group has said in making a presentation and illustrating in the case of Robinson versus Graves. But when it comes to an order of specific goods, it matters not that there are some qualifications in terms of making specifications of whatever good you need to be supplied with. It always remains to be a sale of goods contract because, as Mohammed has rightly pointed out, the main purpose is to have whatever you have ordered, in fact, transferred to you as the owner. Therefore, an order for a special fitting gadget, whether for a Mercedes-Benz or any other car, or even a ship, would be a sale of goods contract. You may read the following case, write down, it's not in the course outline. Camel Raid, Raid, L-A-I-R-D, L-A-I-R-D, versus manganese, bronze, and brass. Manganese, bronze, and brass. 1934, AC 402. Let me ask.
Excuse me, sir.
Yes, please.
We kindly request kind of write-up of these cases so that, because some of us were not getting the names properly, we request.
Why you're not getting the names properly? Just say you do not even have a pen, you do not even have somewhere to write.
I have everything. I have everything. So I have a pen, I have a book, but I'm not getting the names as per your dictation.
Camel. Write down C-A-M-M-E-L. Laid, L-A-I-R-D. The others are issue minerals which you know, manganese, bronze, and brass. 1934, appeal cases 402. Okay?
Okay, thank you, sir.
What if you operate a restaurant and someone makes an order to prepare, and you actually make an order to prepare and supply food in another restaurant? Would that one be a contract or supply of labor and materials or a sale of goods contract? simply to prepare and supply food in a restaurant. What do you like?
That would be the contract for the supply of labor.
To prepare and supply food in a restaurant. Is it a contract for supply of labor or
It is a contract for the supply of labor.
Sir, so
Yes,
from whose
please.
perspective are we talking about? Are we talking about to prepare food and supply in the restaurant between the owner of the restaurant and the chef, or between the chef and the what? And the buyer of the food? There are many contracts happening here. I think between the supply of food itself to the restaurant can be a supply of like a sale of goods contract, but then between the employer and the employee, that is a service being being contracted on.
Tell me a famous hotel in Mombasa.
Sorry?
Tell me a name of a famous hotel in Mombasa.
Blue Room.
Blue?
Blue Room.
Which is that one? Okay. Let me ask you, Mercy, let us say, for example, Pridine Hotel has ordered a consignment of food which you're supposed to supply to them. You will have to prepare and supply the food to Pridine. Is that a contract for supply of labor or a contract falling within the sale of goods contract?
Sale of goods? I'm not sure. Yes, I think so.
Can I try?
Let me
This
attempt
one,
that.
yes.
Let me attempt
I
that.
think once this first there's food which is prepared and cooked. So once it's cooked, I think that will not classify under sale of goods. It becomes contract. It's a service, so it will be under contract for labor. I would say so.
Any other one? Any other person who wish to try?
I think it would be a contract for the supply of services if I am to be asked by the owners of Pridine to move from normally where I do my business, where I operate my eatery, to go and supply my services at Pridine, maybe to cook for them because they have a special function, or otherwise. That would be the contract for supply of services. But if I am in my own eatery, my own restaurant, and I make food and I sell it to other people, then that is a product I am giving out. That is not, I don't think I'm selling a service there.
Hello, may I try? If, for example, you hire somebody at your wedding and you tell them to prepare your food, a cook to come and prepare your food, that's a service. But if you purchase already prepared food from a restaurant, that's a good, according to me.
I agree with
Thank
Boaz.
you. Yes, Kalume.
I agree with Boaz in the sense that an already manufactured, already prepared food, if I'm to order takeaway from somewhere, then they deliver it, that is a good, I think. And I wouldn't go to the definition as per the Sale of Goods Act, but I think that qualifies as a good it would be a service if I were to invite the person to my place to come and cook. Then that would be a contract for services.
Once again, you ask yourself, what is the core or the fundamental purpose of the contract? The fundamental purpose here is actually to prepare and deliver the food. Therefore, once the food is prepared and delivered, that is a good. It is not a contract of sale of services. You're not being contracted to just prepare. The core purpose or the intention of the person requesting you to prepare the food is to have the food itself and not just the service. Quite confusing, eh?
No.
So, Thomas, you are very correct.
No, it's not confusing.
It's not confusing
Yes.
when you put it that way.
Yes, it's not, huh?
No.
Okay. Thank you.
Excuse me, sir.
Yes, please.
Maybe I would like to simplify.
Please do.
Yes, thank you. That the object of contract here is food, and this is what, for example, the Pride Inn Hotel is interested in. That is what it wants. So, and this is what the other party, be it another hotel or an individual or a group, is supposed to supply. So whether the other group is going to hire the people to prepare it, or they are going to command it from heaven like Moses, that is not an issue. What the Pride Inn needs by the end of the day is the food, which is an object. Therefore, we can say it's a sale of good because the services is not an issue. Thank you.
Precisely. Well put. In hire purchase contracts, although we say it's a contract of hiring in which ownership remains with the owner, there is always an expectation that the hirer is likely to exercise his right or option to purchase the goods. If the owner and the hirer are so optimistic that the hirer is going to ultimately buy or exercise his option of buying the hired good, would that very high expectation convert the hire purchase contract to a sale of goods contract?
I'd like to respond to that question.
Yes, please.
And my response is that, from what I read about the hire purchase, is that even as before the hire purchase agreement is entered into, the seller must make it in writing, inform the buyer as to the chance or as to the goods being offered for sale, not hire purchase. So there must be already, the buyer has been informed in writing, or it has been made aware to him that this good that we are offering to you on hire purchase can also be bought for sale. It can also be bought, it can be a contract of sale right away, outright sale, rather than hire purchase.
So where do
I
you
don't know
put
if that answers.
Where do you put the expectation of the parties? Would you rely on the expectation of the parties to convert a hire purchase contract to a sale of goods contract?
Do I rely on the expectations that this person will pay at the end of hire purchase? No.
Thank
I
you.
don't think
Any
that
contrary
would.
opinion? Yes, thank you. Yes. Any contrary opinion? Thank you. Beware expectation, however confident and however well-founded, does not amount to an agreement. Therefore, what Thomas has said is very, very correct. Anyone with a question to the group members?
I have a question,
Yes,
but my
please.
question is generally to you in regard to the Hire Purchase Act.
Yes.
We read that once two-thirds of installments have been paid, not really, but this hire purchase, this price, these installments that the buyer is making every month, as long as they haven't reached two-thirds, if the buyer defaults, then the seller can take back the product and the money the buyer had paid will be taken to be payment for hiring the product during the period in which he was in possession of it. And I would like to go back to the way the Hire Purchase Act protects transactions which are not by body corporates. And I think these are transactions below 4 million, if I'm not wrong, 4 million or 1 million. And I don't understand how
It's
this
4
protection
million.
comes in.
It's 4
Okay,
million.
4 million. I don't understand how this protection for the little man, so-called little man, as is in the notes, if after having paid for up to those two-thirds is way above 50%. And this is something that actually happened to me because I bought a machine on hire purchase. I was with it for a considerable number of time, and then it was repossessed, and then the entire amount was taken to be money which I had paid for hiring. And I do not understand this protection that is argued in the sale of in the Hire Purchase Act in regard to this money being recouped back and only taken as money for hiring. Please comment on this, sir.
Thank you for that. Remember, law has to strike a balance between the owner and the hirer. If you were to take, for example, what you like it to be, that you return the machine and then you also recoup whatever amount you had already paid. It will then mean the owner is disadvantaged in that you give your machine while it's new, but you have returned a machine which is now second hand, and the owner cannot be able to sell it, even able to sell it at cash price, at the same cash price. Therefore, there must be some cost attached to the use of the chattel while it is in your possession. And that cost is actually the cost of hiring. It's upon you to look at the hire purchase terms depending on the contract you are entering into to make a prudent judgment, knowing very well that before you are paid two-thirds of the total installments due, there is an imminent risk hanging over your neck that the chattel can be repossessed. Otherwise, we have to protect both parties. It may appear as if it is not protecting the weaker party, but I do not think so. Perhaps your case was a special case.
I have another question. And this question relates to stamp duty. It is one of the requirements of a hire purchase agreement that it has to be in written form and it has to be stamped. However, whenever a dispute arises, it is said that the failure to have stamped the agreement by the party wishing to rely on it is not really fatal, especially if it had arisen from reasonable factors. Therefore, the court will allow some time for the party wishing to rely on the unstamped hire purchase agreement to have it stamped, then come back. I feel also, I do not agree on that because I feel there's already time that has elapsed between when this hire purchase agreement was made and when the dispute arose. And I assume it is after having paid a number of installments over a number of months. It is therefore reasonable for this party wishing to rely on this agreement to have had it stamped. Why should the court again allow extra time for the party wishing to rely on the agreement to go out and have it stamped, then come back, and then it is admitted? Please shed some light on this as well, because it's an inconsistency that have been coming through in my reading of the Hire Purchase Act.
When you look at the Section 3 of the Judicature Act, you will find that justice ought to be administered without undue regard to procedural technicalities. The same is echoed in our Constitution 2010, I think Article 159, that justice should be administered without undue regard to procedural technicalities. What is just stamping? Does it go to the substance of the contract? Surely it does not go to the substance of the contract. It is just a matter of procedure, and basically is the government in collecting revenue. It adds no value to the terms of the contract between the owner and the hirer. Therefore, it is only fair and just to let the court look at the core substance of the contract, rather than shut out the eyes of the court from looking at the contents of the contract merely because of a procedural issue which involves stamping and collecting of stamp duty. Remember, the owner will also be penalized while paying the stamp duty. And a cardinal rule in our legal system is that a party should not shut out from the seat of the judgment on procedural technicalities, more so if the party who is inconvenienced is likely to be compensated by way of costs. So on the day when the party seeks an adjournment to go and pay stamp duty, you have the liberty of seeking costs of the day to be paid to you. All right?
Very, very clear, sir. Thank you so much.
So a question?
Yes. Yes, please.
I think my mind is very simple. I just wanted to know whether barter trade is illegal in Kenya.
Whether barter trade is illegal in Kenya?
Yes, illegal, yes.
Barter trade is not illegal at all. It is practiced in many communities which are yet to get, I don't want to use the word civilized, which are yet to get accustomed to modern economic setup. It is not illegal. It's only that
I think
it may
that's
not be. Yes?
There's an arrangement I normally see in the sale of cars and other products called trade-in, whereby you can take your old car and then add some little money and then being given a new one. I'm not sure how that amounts to a form of barter, but as long as that is allowed, I think barter trade in Kenya is, because this happens even in big corporates. They offer trade in, so you can take your item and then they'll give you another item, perhaps equal, perhaps for a little money added, or I think sometimes it happens that you can take your product and then they give you another product in the
Malanda,
trading arrangement, and I think it's not legal.
Malanda,
I'd like
Malanda,
to. Oh, sorry.
Malanda, you told us that since there is a price affixed to a product, even if there is an exchange with another product and some cash is added on it, that's a sale of good. You told us that.
Yes, that's a sale of good. I think that clarification in our presentation. And this trading, I think, is sale of good, not barter, because money is affixed to the cars that are exchanged. So therefore, the transaction that are in nature of trading are not barter, but a sale of good.
Thank you so much, my brothers.
Yes, I wish to clarify also that for sure, trade-ins do not constitute barter, but are sale of goods contracts. I am uncomfortable with the case quoted by the presenter, that of Flame versus McKean and Mahon. If its ratio decidedi is that trade-ins constitute barter trade, then it is misleading. The Adridge versus Johnson case is the one whose ratio decidedi is the correct one. Trade-ins, because money is exchanged in addition to the so-called goods or barter, or there is some sort of barter, yes, but the transaction ultimately is sanctioned by payment of cash. That is, and it has been held to constitute a sale of goods contract. It is not barter.
Sir, the issue in that case was not that it was barter. The only question the court raised was these cars, when they were exchanged, monetary value were not assigned to them. That's it. So the cars were not valued. That to say this car is valued this much and this other one is. So the issue was a car for car. Then since monetary value were not affixed, then that was a reason why the court decided it's a barter, not sale of good.
As we see, you said that some money was also paid in addition to the exchange.
Yes, some money was paid, but cars were not assigned any monetary value.
Okay. Can we now move on to the next presenter? Next presentation. Thank you for group 1. Well done. Group 2, welcome. Take over the floor.
Good morning, everyone. Yes, for group 2, our task was to establish the rules on transfer of property. The rules of transfer. Can you go to the first slide, please, Deborah? Rules on the transfer of property. My name is Jared Obuya. Deborah, please. Deborah, can you hear me?
As she's sorting that out, maybe you can introduce the group members.
Yes, the group members. We also need to read that from the second slide. Unless, Patsy, if you have the names with you, you can please do that. Go ahead.
Yes, our group is myself, Patsy Kehio. There is Mary Karaoke, Anne Kigoro, Isaac Ndua, Jared Obuya, Leila Webuye, Patrick Gillo, Deborah Wamayo, Jacinta Nekesa, Mohamed Mwambele, Michael Morethi, and Tabitha Mwangi.
Oh, thank you, Patsy, for that. As she prepares, maybe I could do some introduction. And as I said, our team was to establish the rules governing transfer of property in goods. I just want to say that the term property signifies a legal right of claim, which culminates in ownership upon transfer of title to goods. And the nature or state in which the goods are at the time of sale or agreement to sell determines when the property in them passes to the buyer. For example, property in a certain goods in a deliverable state passes to the buyer immediately the contract is made. And the risk also passes to the buyer even though the seller remains in physical possession of the goods. In determining when property in a certain goods in a deliverable state passes to the buyer, it is usually immaterial whether the price has been paid or not. And then property in a certain goods, usually passes upon delivery, and failure to deliver the goods at the agreed place of delivery constitutes a fundamental breach for which the buyer may reject the goods and recover the price. There is a need to, why should we really determine when property passes? We need to determine when property passes because the risk also passes with the property. And secondly, if the property has passed to the buyer, then the seller can sue for the price. And again, in the event of bankruptcy of either the buyer or the seller, it's necessary to determine whether the goods vest in the trust of the bankrupt or whether the property in them remains in the other party. And then finally, in the event of a resale of the goods by the seller in possession, the subsequent buyer acquires no better title than the seller had. So those are some of the reasons why we need to determine when the property passes to the buyer. I can see that generally it is important to note that the rules that we are going to state here may be modified by the intention of the parties, or as evidenced by their conduct. And now I am going to give the baton to our next presenter, Patrick and Deborah, to state the rules, the actual rules when the property passes. And Deborah will also cite the cases that demonstrate the rules. So over to you, Patrick.
Yes, hello guys. My name is Patrick and I'm taking you through the rules. We've decided as a group that I'll state one rule and then April will speak on its application and case. So rule number 1 is on property of a certain goods in a deliverable state. Where there is unconditional contract for sale of specific goods in a deliverable state, the property passes to the buyer at the time when the contract is made. Goods are said to be in a deliverable state if they are in such a state that the buyer would,
under the contract be bound to take delivery of them. That's rule number one. Deborah?
Okay. A practical example would be an order of 100 reams of A4 printer paper may mean that the property in the goods passes when the order is made, even if the payment will be made after 30 days or the seller will deliver in 6 months' time. However, if the same order had a condition like the papers have to be delivered upon payment of half the price, the property in goods would not pass until this condition has been fulfilled. We also have a practical case of, an English case of Tallinn versus Baxter. In this case, a haystack was sold on 6th January. The terms of the contract provided that the buyer was to pay on 4th February and delivery on 1st. The haystack, however, was destroyed by fire on January 20th. It was then held that the seller was not liable because the sale was of specific goods in deliverable state and that the property had been passed to the buyer on 6th of January.
Yes, thank you. Rule number 2 is property in specific goods not in a deliverable state. Where there is a contract for the sale of specific goods not in a deliverable state, and the seller has to do something to the goods to put them in a deliverable state, the property does not pass until that thing is done and the buyer has not actual notification and not the doing of the act required to be done to put the goods in a deliverable state marks the precise moment when the property in them passes to the buyer.
Okay. For example, the dismantling of a medical equipment in readiness for packaging and delivery must be done by an expert and the buyer notified that this has been done. An English case would be Underwood Limited versus Bag Castle Brick Cement Syndicate. In this case, the contract was for the sale of a condensing engine weighing 30 tons. At the time of the sale, it was still fixed to the floor of the building in which it was installed. It was agreed between the seller and the buyer that the engine would be detached, dismantled, and delivered by the seller. So the seller then detached the engine, he dismantled it, but while it was being taken to the railway station, it got damaged. The buyer then refused to accept it, and the seller sued for the price. It was then held that the property had not passed to the buyer because the engine was not in a deliverable state at the time the contract was made.
Rule number 3 is about property in specific goods in a deliverable state. So where there is a contract of sale of specific goods in a deliverable state, but the seller is bound to weigh, measure, test, or do something for the purpose of ascertaining the price, the property does not pass until that act or thing is done, and the buyer has not paid. In principle, the contract of sale is incomplete and property in the goods in a deliverable state does not pass until there is an agreement as to the actual price payable in consideration.
Okay. For example, if you're buying milk in bulk and for certain unit price per liter, it is important for you to ascertain the exact number of liters delivered before you pay the price and the property in the goods. A good English case would be Simon versus Swift. In this case, a contract was made for the sale of a stack of bark. The buyer undertook to take the whole stack at an agreed price per ton and to pay for it on a specific date. Before the seller weighed the bark to ascertain the price, the bark was drowned. It was held that the loss fell to the seller.
Yes, rule number 4, as you can see in the slide, property in goods on sale on return. When goods are delivered to the buyer on approval or return, the person to whom they are delivered has an option of becoming the purchaser of them, and the property therein passes to him in the following ways. 1, when he pays the price. 2, when he signifies his approval or acceptance to the seller or does any other act adapting transaction. And 3, if he does not signify his approval or acceptance to the seller but retains the goods without taking time or return the goods. That is rule number 4.
Okay. Practical example would be a medical equipment bought on the terms of delivery, testing, and commissioning. Upon delivery, it is tested and commissioned, and if it works, an acceptance certificate is issued and property in the goods passes even if the payment is not made. In the English case of Elphick versus Barnes, a horse was handed over to Barnes by its owner on the understanding that it would be returned after 80 days if Barnes did not think it was suitable for his purposes. The horse died on the third day, and when it died, Barnes had, it was not Barnes' fault. In the end, it was held that the property had not passed and Barnes was not liable.
We are on the second last rule, rule number 5. Passing of property in goods for certain goods. Property in ascertained goods does not pass to the buyer immediately where there is a contract for sale of an ascertained good, not the buyer unless the goods are ascertained.
Okay. When one orders 1 container of milk from New KCC Limited, the milk is packaged and set aside against your purchase order. They then send you an email to inform you of this and you acknowledge it. Going by Section 2E of the Sale of Goods Act, it would mean that the property in the goods has passed. However, going by Section 18, it would mean that the property has not passed until they are ascertained.
Oh, sorry, I think I confused number 6 and rule number 5. That will be number 6. So rule number 5 is, I started with rule number 5. Yeah, so rule number 6. Property in future goods by description and in a deliverable state. In a contract for sale of an ascertained or a good by description and in a deliverable state and goods of that description are unconditionally appropriated to the contract either by the seller with the assent of or by the buyer with the assent of the seller. The property goods therein passes to the buyer. Yeah, that's it. That's it.
Good. My name is Isaac. I was to just say thank you for giving us the opportunity to present. And we've seen that even the risk passes to the buyer together with the property in goods. That is, even the liabilities, the chances to sue, to be sued, you are able to establish this. And thank you for the opportunity. Thank you.
Thank you very much for nice presentation. Questions? Now, in the first instance, it is very true that risk passes with ownership. In other words, if goods are damaged, we will simply look at ownership to determine who should bear the risk. Do you think that is a prudent provision in the Act or rather risk should be tied to possession. Who has the best ability to take care of goods? The owner or the person who actually has custody of the goods? That is, possession of the goods.
Maybe I can come in and
Yes.
state that
Yes.
these are two different aspects. That is the property in goods and the possession in goods. Now, being in possession may bring in the aspect of use of the goods, where the property in goods may not even bring the concept of the use of the good itself. In this case, then, and for the aspect of responsibility, I think the person who, or the person to whom the right is, the property is entitled to, should take further and more aspect of responsibility on the use, and even to know where the good is and how it may have effect even to the environment, even due to the aspect of the tort law. So I think it is good when liability and the risk is attached with the property and not possession, so that the person who is the legal owner takes all aspect of being responsible of that good, whether it causes damage or whatever to the environment or to the neighbors. Then, because being in possession, your child can be in possession of a property, a good that you are registered legally. In that case, you, the person who is registered, and not the person who is using or consuming the good, should be responsible of everything. I think that is a prudent way. But as my submission, I'm ready to be guided.
Yes. Take an example. You go to a supermarket, which is the most famous supermarket nowadays.
Naivas.
Okay, let's say, for example, you go to Naivas, you buy items worth 2 million, and then because they are so bulky, you leave them there. And you just tell the management you will pick the items after 2 weeks, once your counter is back from maybe Kakamega or somewhere. Before the lapse of the 2 weeks, the supermarket catches fire and all your items are destroyed. Whom are you likely, do you have any remedy?
Let me come in as I also invite my group members. I don't think you have a remedy to that, because you bought the items and then on a cash sale basis, and you are there was in a supermarket, they don't deliver for you. It's you pick, you go with them. Now you left them there just by a word of mouth. Maybe it was not contractual even on the normal operations of the supermarket. You went, and in the system of the supermarket, these goods were released from their shelves. So even when it comes to the insurance to pay for the goods in the supermarket, it will be seen that those goods were sold and money was received by the supermarket. So I don't think you have any recourse to that. It's your own fault.
Is it fair?
I think it's fair, because the transfer of property happened when you paid for the goods, and the goods got out of their system and you paid for it, you got a receipt. I think it's fair. Why should you leave your property with someone else and you paid for
I
it?
wish you had to put yourself in the shoes of that particular person. You will feel how unfair it is. Any other interjection? Thank you for your
Would the goods have
contribution.
been covered because they were still in possession of the supermarket?
So shouldn't they be recoverable from the insurance through the supermarket?
The insurance will pay for something that was sold or something that the stock that is already in the supermarket. I think in the system, supermarket system, they sold and actually they received the money and the profit.
But the fact that they were still holding them, doesn't that count for anything?
And under your request, carrying all the responsibilities and the risks.
Probably, if I could add something, according to the according to the Sales of Goods Act, property has already passed, so ownership and liability solely falls on the buyer, because probably why you took 2 weeks, probably you wanted to sell those goods to a third party or something like that. So according to the Sales of Goods Act, property has already passed, so liability and the risk solely falls on the buyer. So I read somewhere, for a case like this, probably you'll have to follow other means of trying to recover your loss, probably follow other litigation measures, but not solely under the Sale of Goods Act, because it's all under the property has already passed, and that is it on the Sales of Goods Act, even though it feels or seems unfair. Thank you.
Hello.
Yes.
So I am of the opinion. Okay, first and foremost, we must look at the figure where the value of the goods, which is 2 million, is a lot of money. So I would not think a person leaving goods worth 2 million will just walk out from the supermarket and just leave them. There should be something contractual, you know, or then again, the supermarket must have taken measures to limit their liability in case of loss. Maybe there is maybe even a poster put up, goods left here in the supermarket will not. The way you walk into a supermarket and you leave your luggage at the security desk. You walk into a supermarket, you buy what you're buying, then you go and exit and take it. Those are they are goods of a lower value usually. But if you go and you find that they gave out whatever you left there to someone else, they should be liable. Yeah, they should be. But in most cases, they will put a notice there that you are not liable for any goods. The goods are left at the risk of the owner. So, unless there is maybe someone leaving goods worth 2 million, most times there should be something that limits the supermarket's liability in case of any loss. And in the absence of which there is no agreement, there is nothing that limits their liability, then again they should be liable. That should be especially for goods of that value. Yeah.
Maybe another question we can ask ourselves is mostly the goods in supermarkets and the price tags that are in them is all a concept of invitation to treat, of which maybe you pick the good, then you go to the counter, you pay for it, you execute the contract. Now, did this person pick the goods, go with the goods to the go with the products or the goods to the counter, pay for them, or was it also a request or a conversation with the management that I'm paying for this, you'll supply later? But if you went there, identified the good, went to the counter, paid for it, then you request the supermarket without any aspect of assessing the liability in the event of anything, that you come and pick the goods, as the lecturer said. The liability, I think, falls with the buyer.
Thank you. It is a cast in stone rule. It has no exceptions. And it is the legal position that the risk in goods passes with property. Therefore, you leave these goods at your own risk. I don't know whether in thought you have dealt with the two scenarios of injuria sine damnam and damnam sine injuria. Injuria sine damnam meaning injury without damage, and damnam sine injuria meaning damage without injury. I'm sure you will deal with that. If you're not yet dealt with that, there are instances when you may find yourself without a remedy. Okay, what do we really mean by deliverable state? Is actual knowledge required of the buyer that the goods are in a deliverable state? And in that regard, suppose the seller sends a notice via post, and the notice contained in the letter posted gets lost. In the notice effective, can we say the buyer has knowledge? If you recall the postal rule in general law of contract, would it apply, or in this particular case, we should actually insist that actual notice is given to the buyer? Yes? Group presenters?
Yes,
or
normally
members?
the rule says that the buyer must take notice of that the goods are in a deliverable state. So if he does not have the knowledge, if the letter gets lost, then we cannot say that he does not take possession of the property. The property is not his, not property.
Do you agree, class members?
I think what can also be checked is when the person who was giving, the party that was giving the offer, the format in which he communicated, so that the offeree could also communicate back. If it was maybe through the letter, as we follow the postal rule, then we can say there was a communication in it. If from the aspect of the offer and acceptance, they used notices.
The opinion of other class members, including who should give notice to the buyer? If you look at the act, it is silent. It does not say who should give notice to the buyer.
I think that the buyer himself must see the goods and accept that it is in a deliverable state, because it says until the buyer has notice of it. So my reading is that he must accept that the goods are in a deliverable state.
I asked who should give notice, because from whatever you are stating, it's not clear who should give notice.
I believe in the spirit of the law, in the spirit of this act. What is behind is that the buyer should receive the goods receive them, look at them. If he's satisfied, he is the one to give notice back that he's received them and claim and inform the seller that I've received them and accepted them. But there is also a place where there's some noise. I'll be back in a minute. Let me sort that out. Sorry.
I'm looking at rule 3. And that's why I'm asking, who should give notice that the goods are in a deliverable state? And should notice be actually received by the buyer, or it's enough to just send a notice to the post office, regardless of whether it reaches the buyer or not, provided it is properly addressed?
Let me make a trial and say this. From the onset, these two parties had their own communication towards the contract they are engaging into. And there is the method, because I believe when we talk of notice, it doesn't maybe mean just a notice. It could be a notice, that format of giving the information, even could have been a telephone, could have been an email, which is given by the seller communicating to the buyer that now the goods are now in a deliverable state, either for the buyer to come and check the goods or request for them to be delivered into, to the buyer's premises. I think the notice in this case is silent. It may be a letter, maybe a telephone conversation, maybe an email, fax, or the way they both parties intended to communicate between themselves.
Well, it is submitted that provided the buyer has notice, it is not relevant who provided the notice. It does not actually have to come from the seller. It can come from the seller's agent or any other person for that purpose. What is important is that the buyer has actual notice, and the notice must be communicated to the buyer. Let me give a scenario, and I ask you whether this particular good is in a deliverable state. A orders a new car from B, and B delivers the car without registration plates. Is the car in a deliverable state? Yes? I've said A orders a new car from B, and B delivers the car without registration plates. The question is the car in a deliverable state?
Is the class allowed to attend?
Yes, please. Proceed. Wanjiru, proceed.
I would say, well, I'm being naive and would say yes, because isn't the registration of a vehicle the responsibility of the owner?
Thank you for your input. Do you agree with that?
So for me,
yes,
I don't know what customarily happens when people buy cars, who delivers, whose duty it is to offer this license. But if customarily it's not like a duty of the seller, And if in the contract it was not agreed that the seller would provide these registration plates, then I assume that it is in a deliverable state, because as per the act, if the goods are in a condition where the seller is contractually, the buyer is contractually obliged to accept them as per the terms of the contract, then they are in a deliverable state. So unless they agreed that the seller would provide these plates, or customarily the seller does provide these plates in the course of the business that they're doing, then I would assume that they are in a deliverable state.
Can I try?
Please try. And thank you Mercy, for the trial. Yes, Michael.
I am thinking if the car does not have registration, then establishing the owner, that you could verify that he is the actual owner of the car, there could be a question in that. So for me, I think I would try and establish if there is ownership, and the ownership belongs to the seller, and then once I establish the ownership, then I would accept. But without any form of registration, I wouldn't be in a position to accept.
Let me come in with a practical.
Thank you for that. Yes, Baru. Is it Dua? Yeah, thank you.
Yes, but we've been seeing a situation whereby someone buys a vehicle from a car dealer. They've not registered. They don't have the car registration plates or number plates, but they do sell that vehicle to you, and you even travel with the Kenya garage numbers for a certain period of time, waiting for the preparation or the registration plates to come, the car number plates to come, and you just move with the vehicle. In this case, I believe you have taken the property of the good. You've even taken all the risks that pertains to it, meaning this item or the vehicle has been delivered to you, even if the registration number plates has not come, you can wait for them. I think so.
Well, the court's opinion is that the vehicle is not in a deliverable state because you cannot be able to use that vehicle. It's illegal to use a vehicle which does not have number plates. All right? What appears easy is not always easy.
But that's not what has been happening, Malim. People are traveling with vehicles in the Kenya garage. Number plates allowed.
And that is a registration plate. You cannot travel without any registration plate. All right?
Okay.
So if you Kenya garage, if you buy and you get the KG plate, it's a plate. It's all right. At that point in time, it is in a deliverable state. But if no plates at all, it is not in a deliverable state. All right? What do you assume? Isaac, assume you own a wholesale or a depot, for example, of selling, let's say, of selling sodas inside, and then someone comes and then says, and I have 500 crates out of the 1,000 crates in the store. What did you say about that kind of contract?
You're saying a client comes and demands that
The crates in a delivery. What did you say about that kind of contract? A client comes to your store and then says, I would like to buy 500 crates of Saunders out of the 1,000 in the store. And he pays the price. But he leaves them there, perhaps to come and pick them later. Another client comes and makes a similar order. And the third one also comes and makes a similar order. All of them leaving their purchases with you with the intention of collecting them later. Are those another contract on sale?
Yes, I can't say it's a contract of sale, but because the goods are there, and you have the goods, and these persons are leaving their cash with them to come and collect the goods later. But now also you are also selling beyond what you possess.
Can I make a try?
Thank you for that. Yes, try.
Now, I think in this case, can you hear me?
Yes, I can hear you.
I think in this case, this is a case of unascertained goods because the buyer never specified the specific item he's buying. So it's a case of unascertained goods. So I don't think the buyer there has any claim.
No, Mike, the buyer has
Thank you for
identified
that,
the
Mike.
500 crates. I was trying to respond to Mike and saying the buyer came to the store, found the 500 crates, paid for them, and the property, of course, transferred, even if the buyer did not carry the crates. The issue now comes in that in the event now the seller sells beyond what he has, because if they were 1,000, he should have rested at the second client, waiting for them to come and get the goods because they're the ones to pick them. So the risk has transferred to the buyers up to the figure of the 1,000 crates for the two clients, and the risk of anything that may happen in my store by the fact that they've not come, I think it's upon them because they already bought and they were to go and pick their vehicles to come and pick them.
Can you say that those goods are properly appropriated into the contract, Isaac?
I can say they are properly appropriated money because this client came to my shop, needed the 500 crates, of which he was also to provide the means to deliver to his premises, then goes to and gives me the money. So the property got transferred from me to him. Whether he comes in the morning, in the evening, at night to pick his items, as far as there is a possibility of opening the store to him, I think the contract was well entered and the goods transferred to him.
Mwalimu, I just want to find out, the seller already sold the goods and now I feel as if for the second, he cannot sell what he does not have. If he has already sold the goods to the first buyer, and then he cannot sell what he does not have. I don't know if the Nemo Act rule can apply there.
I think
Yes.
if the buyer came and said, okay, I want 1,000 crates, but you only have 500 crates, and then those crates are set aside, and specifically they are ascertained that this and this and these crates are mine, then the buyer has a claim. But if he just came, paid, he's told we have just 500 crates, and it's not specific, then the buyer doesn't have a claim, does not have a right to those goods specifically. Thank you.
But there is also another
Thank
end
you
to
very
it.
much. Thank you very much. I was testing your understanding and application of appropriation and setting aside. And Mike, you have captured it very well in your last proposition. For an appropriation, there has to be an apparent intention to attach the goods irrevocably to the contract. Hence, for example, if A is buying 6 sacks of maize from B, and B loads 50 sacks in his lorry to go selling to others, A's 6 sacks are appropriated once identified and removed from the lorry. If, however, B stores the 6 sacks of A separate and distinct from his stock in the store, then that would be an act of appropriation. B would be retaining the 6 sacks for B's collection. That is for A's collection. Property would pass when the 6 sacks are set aside for storage. Clear? Can we go to the last presenter then? Last presentation, that one is easy. Last group.
Hello. So we will be presenting on the rules of delivery. Margaret, please present the slides. Thank you. So the group members are myself, Arike Masi, Chelsea Owino, Michael Mbaru, Mwanaizdi Chizuka, Nuru Omar, Eugene Ngao, Momachi Mwakireti, Anne Kanini, Hamis Fatma Bakari, and Nuru Omar. So we looked at the Act itself. Section 30 of the Act, it is termed Rules of Delivery. There are 5 rules there. So each group will be presenting on one rule. Each group is made up of 2 people, except for one group that has 3 people. And then at the end, there are also some other rules that are sprinkled around the Act, and even just in this part. And at the end, we will come in and mention also those rules. So starting with rule number 1, which is section 30, subsection 1. Whether it is for the buyer to take possession of the goods or for the seller to send them to the buyer is a question depending in each case on the contract, expressed or implied, between the parties, and apart from any such contract, expressed or implied, the place of delivery is the seller's place of business if he has one, or if not, his residence. Provided that if the contract is for the sale of specific goods, which to the knowledge of the parties when the contract is made in the same place, then that place is the place of delivery. So I will let Chelsea come in, and then she will invite the next speaker. Thank you.
Right, thank you so much, Enrique. Thank you, Margaret, for sharing your screen. I will continue. So we went ahead to define the various terms that we saw that needed to be defined, because in law, when you come across a word, it is very important for you to define it, not only for your benefit, but for the benefit of the rest. So in this case, the Sale of Goods Act provides a definition of buyer as a person who buys or agrees to buy goods, whereas it goes ahead to provide the definition of the term goods, which is, or rather, which includes all chattels, personal, other than things in action and money, and all implements, industrial growing crops, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. The next slide, please. And then we have the definition of the term delivery, seller, deliverable state. In this case, delivery means voluntary transfer of possession from one person to another, right? And then seller, we have a person who sells or agrees to sell goods. And then deliverable state, which I have seen being mentioned quite a number of times in the previous group presentations, is that the goods are in a state that the buyer will kindly mute your mic to the one whose mic is unmuted. Thank you. So deliverable state is the goods are in state that the buyer would, under the contract, be bound to take delivery of them. So kindly move on to the next slide, please. Right, so now I went ahead to, or rather we went ahead to break down the rule, which is the first rule, and we say that it is excuse me, to the person whose mic is unmute, it's really causing some sort of disturbance. There is an echo when I speak. Please go ahead and mute your mic, kindly.
Excuse me, is it Chelsea who's speaking?
Okay.
Chelsea, are you the one who's speaking?
I'm the one who's speaking, sir. Yes,
Okay,
but it's
fine.
someone else's mic who's unmuted. Yes.
That's Kidada.
Yes, please mute your mic, kindly. Okay, I will just continue.
Muted it. It's fine. Let's continue.
Okay. Thank you very much, sir. So we went ahead to break down the rule itself, just from what was written in the Sale of Goods Act. And what you see from now till maybe the next person comes in is basically what our thoughts are, combined with things that we might have found on relevant sources. So it is the duty of the seller to deliver the goods. Dispatching of the goods is a matter of contractual interpretation. And if it is agreed upon within the contract that the seller is to deliver at the purchaser's premises, then it is enough that he delivers them to a respectable person-looking person. And this was found in the case that has been written there, which is Galbraith and Grant Limited versus Block 1922. So I'll just expound on this very, very briefly. So in this case, if maybe two people agree, let's say me and Enrique, or Enrique and I agree that Enrique is the seller, I'm the buyer, and Enrique says that, you know, I will deliver the goods to your place, or that to the purchaser's premises, to my premises, then that means that the person who is responsible for delivering them must not go and leave them at the gate and not inform anyone, right? Like you go put the goods on the gate and say, you know what, I deliver the goods, I didn't find anyone, but I deliver them at your premises. That wouldn't be, you know, as per what you might have agreed on earlier on. So in this case, it is enough that the person who delivers them does so to a respectable person-looking person. This could be maybe the security guard or anyone else that maybe the buyer had instructed the seller to deliver the goods to. Moving on, however, it is still the duty of the seller to put the goods in a deliverable state, regardless of whether or not he or she is contractually obligated to dispatch the goods to the buyer. I think that one is okay as it is. Next slide, please. And that the place of delivery, so this is, I think this should be the second part of the rule itself, still within the same rule, that the place of delivery, meaning the place where transfer of possession is voluntarily passed to another, is either A, the seller's place of business, right? Or B, the seller's residence, if the seller does not have a place of business. So in this case, it is very, very clear that in the case where the seller does not have a place of business, then it is okay upon contractual agreement or upon agreement between the seller and the buyer that the seller's residence, that the seller's residence will be now the place where the goods could be delivered. But then you cannot say that, for example, just a very, very brief example to make it more realistic. If we have a seller and a buyer, and then let's say the seller delivers it to the place of business, or rather the buyer does not inform the seller that, I don't have a place of business, so please deliver it to my place, for example. And maybe the seller thinks that, oh, you know what, this person has a place of business, so I will take it to maybe a random place. But that one wouldn't really make sense, because now in this case, the seller should have been informed prior to delivery that, you know what, I don't have a place of business, so how about you bring the goods to my residence, right? That will be the better way of putting it, instead of just leaving the seller to figure it out, and in the long run, your goods end up being lost, if that makes sense. Right, so the next one, and if, oh wait, sorry, I might have given the wrong explanation, so I think we could just go with what has been written in the above. So I'll just go over it one more time to avoid any sort of confusion. That the place of delivery, meaning the place where transfer of possession is voluntarily passed to another, is either A, the seller's place of business, or B, the seller's residence. If the seller does not have a place of business, I think that is self-explanatory. I don't need to bring in another example to cause more confusion if there is any confusion. I will move on to the next slide. And if both parties are aware that the specific goods are in some other place, then that place becomes the place of delivery. Next slide. I think that should still be under us, if I'm not wrong. Yeah. So the rules to the exception of place of delivery. The first rule to the exception of place of delivery is that the goods in question be specific goods. So these goods cannot be random goods that someone just thinks of at the top of their mind. They have to be very, very specific goods. And then the second one is that both the buyer and the seller be aware that the goods being contracted on are in some other place. So those are the two rules to the exception of place of delivery. The next slide. So in this case, or rather therefore, a seller who knows that their goods are in some other place and does not make the buyer aware to, cannot later try to deliver the goods at some other place other than his place of business or his residence. I could explain this in some maybe easier language or easier way. So in this case, a seller who knows that their goods are in some other place and does not make the buyer aware to, cannot try to deliver the goods at some other place. So basically this means that if a seller, meaning the person who is responsible for selling the goods in layman's language, if the seller knows that their goods are in some other place, meaning a place that has not been made aware to the buyer, this seller cannot later try to deliver the goods at some other place other than his place of business or his residence. So I think if you remember, there was a slide where we talked about, I think, the place. The seller can deliver the goods to either the place of business or the residence. So this seller cannot come in and try to deliver the goods maybe to the buyer's friend's house, or to the buyer's grandmother's house, or to the to the buyer's grandmother's place of business rather. The goods can only be delivered to either the place of business or the residence in that case. I think that should be clear. And then the second rule, I will call upon the next two people to come in and give their presentation. The people in our group, please continue. Let me just check who it is. Just a minute.
That's me, Chelsea, me and Nuru.
And the two people,
good morning.
Yeah, please go ahead.
So we'll be presenting rule number 2, my friend Nuru and I. And then we also we were 10 in the group, and then we had an addition of another one, that's Maggie. And we decided Maggie will work on 2 groups. So we will be presenting with Maggie. I'll do interpretation, Nuru will do case law, and also Maggie will do another case law. So in rule number 2, where under the contract of sale, the seller is bound to send the goods to the buyer, but no time for sending them is fixed. The seller is bound to send them within a reasonable time. Can you go to the next? Yes. So in the interpretation part, a seller has a duty to make a timely delivery. When one wants to estimate the reasonable time, he or she should be judging all existing circumstances and aspects of delivery of the said goods from the seller to the buyer. This rule applies when the time for delivery is not specified. I would like to elaborate more on the interpretation. So, like my colleague Chelsea in the first slide, in the first rule, said there is an exception. So in point 2, that would be the exception for delivery within reasonable time. And when we say reasonable time, this applies to circumstances and aspects of delivery. This will be the exception in this rule. Let's go to the next slide so that I can explain what I'm saying in details. So in the absence of an express provision in a contract of sale as to the time of delivery, a provision may be implied in some cases. For instance, in the case of goods which to the knowledge of the seller are needed for a certain purpose of a certain time. So here I would just make an example. If IEBC is ordering for ballot papers, it is only reasonable that the papers are delivered to their offices within that time when they are preparing for elections, and not after the elections. That's what it would mean to have goods delivered in a reasonable time. In point number 2, if there is no express or implied terms requiring delivery at a certain time, the obligation of the seller is to deliver within a reasonable time. So sometimes people will not say what time. So maybe, again, let's talk of IEBC. They didn't say they want the papers what time, but we all know the elections are supposed to happen from this month to the next month. It's going to be unreasonable for the one who's given the tender for the ballot papers to deliver the papers way after the elections were done, the tallying was done, and another person maybe was procured to do that same job. So maybe the IBC officials didn't say what time, but since the person who was given the tender to procure the papers should know that at this time or from this point, I should have delivered the ballot box papers before expiry of the period or exercise for elections. Another example would be, maybe there was a function for children and you needed to deliver milk, and you deliver milk way past that function and the children have been released to go to their homes, then that would not have been a reasonable time. I hope everyone is getting my point. So on to the third point, the question what is a reasonable time depends on the actual existing circumstances, so that the time for delivery may be extended by circumstances necessarily involving delay, such as a strike, except insofar as the circumstances are caused or contributed to the seller. So I would maybe pinpoint not specific case, but I'm aware that sometimes people go to court because of admiralty cases. Maybe the containers were late and the goods that were supposed to be delivered were late by 2 months. But again, you find it at the port, at the Kenya Port Authority, there are procedures to be followed. And maybe the shipment that was docked, after inspection, there were some requirements that were not met. And you find that for the person who had the ship, they're trying to curb they're trying to meet the requirements that they were supposed to meet. And in so doing, the buyer or the buyer, the one who's supposed to get the goods, the consumer, is delayed. So you find this is a circumstance that could not be avoided. So that's why we are saying reasonable time also depends on the actual existing circumstances. But when it goes beyond a year, that is not okay to the consumer. We will have caused major damage to the consumer. Maybe he had perishable goods. Maybe he had also time to meet when selling his goods, or whatever reasons he had for his goods for that time. Let's go to the next slide. Nuru will come in to explain this case study. Thank you. I will take questions after my friends have completed their presentation.
Okay, thank you, Mwanaidi. This is Nuru. So, in a case, this is the case study, an English case of Hick versus Raymond of 1893. In this case, there was a dispute regarding shipment of a cargo containing grain that was to be delivered in London. However, there was no specific date for when the consignees were to take discharge of the grain. Since there was no specific date for the delivery in the contract, the House of Lords held that the consignees were not liable for the shop owner's delay. Lord Herschel LC said, "The only sound principle is that reasonable time should depend upon the circumstances which actually exist." When I say the circumstances which actually exist, I of course imply that those circumstances, insofar as they involve delay, have not been caused or contributed to by the consignee. Okay, as far as I see it, it's self-explanatory, so I'll hand it over to Meg to do the other case. Thank you.
Good morning. I hope everyone is having a good morning. I'll tackle the case of Hartley versus Hymans, whereby a contract for the sale of cotton stipulated that delivery was to be made in installments by a specified date. The buyer accepted a number of deliveries after this date, however, and continued to press for performance for a subsequent period of 4 months, at which point he refused to accept any further deliveries. The Honorable Lord McCarty J. held that while time had originally been of the essence of the contract, the buyer's conduct amounted to a waiver of this stipulation. It was not open to the buyer consequently to terminate the contract abruptly, though he would have been entitled to do so had he given the seller notice of his intentions. In this case, it's pretty much self-explanatory in that there was a specified time of delivery. However, the buyer still continued to accept a number of deliveries after the specified date. This was an indication of an implied waiver of the initial stipulation. Therefore, the buyer could not terminate the contract later on because he had already waived the initial stipulation. So it's basically self-explanatory. I'll leave the floor to Suhail and Fatma to take us through rule number 3.
Thank you, Meg. Good morning, everyone. So I'll take you through rule number 3.
Section 30, subsection 3 of the Sale of Goods Act states that where goods at the time of sale are in possession of a third person, the seller cannot deliver the goods to the buyer unless and until the third person acknowledges to the buyer that he holds the goods on his behalf, provided that nothing in this section shall affect the operation of the issue or transfer of any document of title to goods. So some keywords you came across include sell. A sale includes a bargain or is the action of selling something or the exchange of commodity for money. Another one is the third person or the third party, who is a person or a group besides the two primarily involved in a certain business. So if during the sale, the goods are possessed by someone else other than the seller or buyer, the buyer or which is the third party in this case, a delivery shall not have taken place unless the third party tells the buyer that the goods are being held on the buyer's behalf. So what follows is the example in the case law, which I invite Fatma to take us through. Thank you.
Good afternoon, and I'll be taking you through the practical example. First of all, person A sells belts of clothes which he buys from Desmond, but he does not take possession of the goods from Desmond. Person B comes to the building and wants to buy several belts of clothes. The rule states that where the goods at the time of the sale are in possession of a third person, there will be delivery only when that person acknowledges to the buyer that he holds the goods on his behalf. Therefore, in this case, Desmond has to acknowledge to the buyer, who is person B, that he has possession of the goods to be delivered. Next. In a case study of Warders Import and Export Co. Limited versus W. Norwood and Sons, the sellers sold to the buyers 600 cartons of frozen ox kidneys, part of a consignment of 1,500 lying in cold store in the possession of a third party. The buyer's carrier took delivery the next day. When he arrived at 8 a.m., he found 600 cartons standing on the pavement on bogies awaiting his arrival. He handed over a delivery order to an official employed by the third party, and this was accepted by the official. Loading the meat into the carrier's refrigerated lorry was completed by 12 noon, and by that time much of the meat was thawing. The carrier did not put on the refrigerating machinery in his lorry until 10 a.m., and it did not become effective for hours. On arrival at the buyer's premises, the meat was condemned as unfit for consumption. The sellers contended that the property in the meat had passed to the buyers under Section 18 of the Sale of Goods Act 1893, and that the loss fell on the buyers. It was held by the Court of Appeal. The property had passed under Section 18(5)(1) because there had been an unconditional appropriation of the goods to the contract. When goods were in possession of a third party, appropriation occurred when he acknowledged that he held them on the buyer's behalf. When the carrier handed over the delivery order to the official employed by the third party, and this had been accepted, the acknowledgement required that had been made. Accordingly, the risk of deterioration passed at the time under Section 20 of the Sale of Goods Act 1893. Thank you for that, and I'll be yielding this to the members of rule number 4.
So good afternoon. So rule number 4 will be covered by Michael Mbaru and I, Churchill Mwakireti. And it states that demand or tender of delivery may be treated as ineffectual unless made at a reasonable hour. And what is a reasonable hour is a question of fact. Next slide, please. So from the rule itself, you'll find out that it is divided into two parts. The first part talks of delivering it, a delivery being considered as ineffectual at a particular hour, unless the hour is reasonable. And then the second part will talk about what do we mean by reasonability of an hour being a question of fact. So you'll find out that delivery must be made at a reasonable hour, and where the seller has agreed to send them to the buyer within a reasonable time. In practice, of course, time is likely to be of the essence in a commercial contract, with the failure to deliver being actionable breach of the contract. For instance, the moment if a delivery was to be made at let us say 10 a.m. as per the terms of the contract, and you make the delivery, let us say at 9 a.m., then it can be considered as ineffectual and as a breach of contract. Next slide. So the seller is required to tender delivery of the goods at the time stipulated in the contract. Where the contract of sale requires the seller to send the goods to the buyer, no time is fixed for their dispatch. The seller is required to send them within a reasonable time. Now, we'll replace the time with hour, especially for contracts whereby the date has been decided. For instance, if it was to be sent today, then the time to be sent should be within a reasonable hour. So reasonable hour will depend on the circumstances of the case. It will be influenced by also the nature of the goods. For instance, perishable goods should be delivered in advance. For instance, you'll find out that hotels, most of the goods in hotels are delivered very early in the morning. For instance, bread, to avoid servicing of bad bread. So you'll find out that, okay, let us move to the next slide, please. So a good example, we found a case here that in a case whereby the delivery of goods to a building site was done outside the working hours. And this resulted in there being left of an unlocked garage. And this was held not to be the delivery at a reasonable hour. For instance, you deliver, let us say, cement in a construction site at around 3 a.m. That doesn't seem to be reasonable because there's no one there to receive the delivery. And the case is there. Let us go to the next slide. So you'll find out that what is considered a reasonable hour is majorly defined from the customary manner of handling businesses. So for instance, if normal business hours might start from 8 a.m. to, let us say, 5 p.m., then if you are to deliver the goods today, then that period will be considered, any time between that period will be considered a reasonable hour. In other cases, for instance, you'll find out that other businesses do their deliveries at 3 a.m. For instance, the seller, it's customary for the seller to deliver his goods at 3 a.m. Therefore, if he does that, then that can also be termed as a reasonable hour. So I will let Mbaru to continue. Thank you.
Thank you so much, Mwamachi. And I think you have done a great deal in terms of unpacking what the rule says. So for me, I will just lay more emphasis on why the goods must be delivered within that hour that has been agreed. And in most cases, you find that where time is of the essence and that is stipulated within the contract, then late delivery constitutes a breach of condition, and the buyer can reject the goods, terminate the contract, and also can go ahead and sue for damages. The importance of delivering within the hour as agreed is that maybe some transactions, especially commercial contracts, are string nature, such that I would need the particular good at this time because I want to transact those particular goods also at a certain time to a different buyer, for example. So as provided on the slide, this is important because certainty in commercial contracts is important, particularly in string transactions involving a series of sales of the same goods or transaction in which goods are bought for use as materials or components in the manufacture of other goods. So as a failure to deliver on that particular time, it's presumed to be a breach of condition. The buyer is entitled, unless this presumption is rebutted, to repudiate the contract, regardless of whether the breach has resulted in loss or damage. So how about early delivery? Early delivery, accordingly, is no less a breach of contract than late delivery. And the courts have also taken a similar approach to the time of performance of other contractual obligations, such as giving of notices to that time in respect of time delivery. Though time of delivery is prima facie of the essence of the commercial contract of sale, it can be expressly or impliedly waived by the buyer. And we have seen in the previous that the conduct of the buyer sometimes can imply that he has or she has waived that hour or time of delivery. We can go to the next. So the rule that hour of delivery is of essence applies to ordinary commercial contracts of sale, but not in the absence of an express or implied intention to the contract. To consumer sales contracts, stipulations as to time of delivery in commercial contracts have been held by the courts to be of the essence. And in conclusion is that the contractual obligation must be performed within the prescribed hour, if any, or within a reasonable time. If the contract specifies the date of performance, time, it will be of essence of the contract, and performance, therefore, non-performance, therefore, damages the contract. I will now invite my other colleagues to continue the rule number
5. Good afternoon, everyone. So, with reference to Section 35 of the Sale of Goods Act, rule number 5 provides that unless otherwise agreed, the expenses of and incidental to putting the goods into a deliverable state must be borne by the seller. So what do I mean? It means that it is the sole responsibility of the seller to see that the goods are in a deliverable state. This rule as to the delivery of goods therefore implies that the seller bears all the costs, assuming as to the mode of delivery of the goods. I tried looking at what the term deliverable state means, and I got the meaning from a particular case where the judge said that a deliverable state does not depend upon the mere completeness in all its parts, but on the actual state of the goods at the date of the contract and the state in which they are to be delivered by the terms of the contract. So I'd like to invite Anne to talk about a case. Thank you.
Thank you. I'm Anne Mulinge, and I'll expound on this rule as illustrated in Underwood Limited versus Bar Castle, Brick and Cement Syndicate. So this is a case that involved an engine which weighed 30 tons, which was sold to the buyers and was to be delivered on rail. Before it could be delivered, it was to be detached and its pieces placed on the rail. The expenses of detaching it were to be provided by the seller. Unfortunately, after detaching it, they damaged it while loading it on a truck, resulting in the buyer's refusal to accept it. And it was held that the owners of the engine could not sue for the price. Lord Banks was of the view that the sellers had sole responsibility to see that the goods are in a deliverable state, namely detaching it and placing its pieces on the rail, thereafter the property being passed to the buyers. However, in this case, the engine was not in a deliverable state as it was damaged before it could be put on rail. In agreement, Atkin Lord was also of the view that the risk of delivery on the rail was to be borne by the owners of the engine. And thank you. I'll yield the floor to Arike.
Thank you. So those are the 5 rules that you will find under section 30 of the Sales of Goods Act, and they are aptly termed rules of delivery. However, if you continue going through the Act and even in some other places of the Act, you will find that there are other rules of delivery that are not necessarily termed under rules of delivery. So those are the rules that we are going to deal with right now. And the first one being, the first 2 being that the seller has the duty to deliver, and that payment and delivery are concurrent, have to happen concurrently. So Chelsea will present on these 2, and then lastly, I will come and finish with all the other rules, and then we will take questions.
Perfect. Thank you so much, Arike, for that, and the rest of the group members for a terrific group presentation. I will go ahead and present the first 2 rules, and then Arike will do the rest as she has mentioned. So the first one is under section 28 of the Sale of Goods Act. And if I may go ahead and read it, it states the duties of seller and buyer, and then it goes ahead to say, it is the duty of the seller to deliver the goods and of the buyer to accept and pay for them in accordance with the terms of the contract of sale. So I will go ahead and expound on that as I do so with the other rules, sorry. So aside from the fact that the seller is not generally bound to deliver the goods in the sense of physically dispatching them to the buyer, although the buyer is bound to take them, the duty of the seller to deliver the goods is a somewhat ambiguous concept covering 3 different possibilities. There may be a duty to deliver to the buyer goods in which the property has already passed. Here the duty is specific. So this is the first possibility. And yeah, this is the first possibility. As I've mentioned before, that there are 3 different possibilities. So the first one is, there may be a duty to deliver to the buyer goods in which the property has already passed. So in this case, the duty is specific and subject to the question of payment. It is a duty which will be breached should the seller fail to deliver those particular goods. And if the property has already passed, there can be no question whatsoever of the seller substituting some other goods without the consent of the buyer. So they must deliver those particular goods and no others will do. Right? And then the second possibility, alternatively, the seller's duty to deliver may be a duty to procure and supply goods to the buyer in accordance with the contract, but without designating any particular goods that are to be delivered. Therefore, in a contract for the sale of purely generic goods, the seller is in one sense bound to deliver the goods, but there is no duty to deliver any particular lot of those goods. And until such a duty arises, the seller is free to deliver any particular quantity of goods that meet the contract description. So in this case, if the seller were to procure goods corresponding to the contract description, intending to use those in performance of the contract, but changes their mind and sells them to someone else, the buyer cannot complain that the seller has broken their duty to deliver. Right, and then the third possibility is it may be that the seller is under a personal duty to deliver a particular lot of goods, although the property has not yet passed to the buyer. This is always the case where there is an agreement to sell specific goods, where property in them has not yet passed. So in this case, the seller cannot resell those goods without being guilty of a breach of contract. Right, so I will go ahead and expound a little bit more so as to not take as much time, as this one is very broad, before moving on to the next one. So even in the sale of an ascertained goods, it is possible for the seller's duty to deliver to attach to a particular lot of goods before the property passes. This, for example, is the effect of a notice of appropriation in a CIF contract which does not pass the property but fixes the goods to be delivered. So you might be asking, what is a CIF contract? I will go ahead and give you the definition of it. So cost, insurance, and freight is an international shipping agreement which represents the charges paid by a seller to cover the cost, insurance, and freight of a buyer's order while the cargo is in transit. So the goods are exported to the buyer's port named in the sales contract. Right. And then similarly, in an FOB contract, where the seller ships goods but retains the bill of lading as security, the seller will come under an obligation to deliver to the buyer the actual goods shipped, though the property remains with the seller for the moment. Right. And then in this case, again, an FOB contract, I will just go ahead and briefly define it. An FOB contract, otherwise known as free on board contract, is a contractual term in the sale of goods under which the seller bears the cost of delivering goods via a specific route determined by the buyer. So once the goods are on board, property and risk passes to the buyer. Perfect. So these three possibilities are not mutually exclusive, but three stages in the performance of the contract. So the duty to deliver may start by being unattached to any particular goods, may then become attached, and finally the property may pass. So on the other hand, the three stages may be merged into one, as in a sale of specific goods, or two of them may be merged where goods are appropriated to a contract, fixing the duty to deliver and passing the property at the same time. I will move on to the next rule. I will briefly explain it since I do not want to take in more time. That way we might allow Arike to come in with the rest of the rules. So the other rule comes from Section 29 of the Sale of Goods Act, and it's payment and delivery concurrent conditions. So unless otherwise agreed, delivery of the goods and payment of the price are concurrent conditions. So that simply means that the seller must be ready and willing to give possession of the goods to the buyer in exchange for the price, and the buyer must be ready and willing to pay the price in exchange for possession of the goods. In layman's language, I would say that this is a give and take kind of situation, right? Because in this case, just looking at the section itself, Section 29, in this case, the seller must be ready and willing to give possession of the goods to the buyer in exchange for the price. So as the seller gives something, they are also, taking something else, and vice versa. That is in very layman's language. So it is not necessary for the seller actually to tender delivery before being entitled to sue for the price or for damages if it is clear that the buyer would have refused to accept the goods, but it is enough that the seller was ready and willing to do so. And then similarly, a buyer need not formally tender the price before becoming entitled to sue for non-delivery, provided that they were ready and willing to do so. So although the seller does not have to make a formal tender of delivery, they must have not only the disposition, but the capacity to perform the contract. And then my last point before I bring on Arike, this rule, however, must be reconciled with another established proposition, that if the buyer wrongfully repudiates the contract, the seller can accept the buyer's repudiation and then maintain an action, even though it is shown that they did not have the capacity to perform the contract when the buyer repudiated it. So in this case, if the buyer meets the seller's claim for damages by pleading that, notwithstanding that they previously gave an unjustified reason for repudiating, the seller was themselves in breach by failing to deliver at the appointed time, or in other words, in the case of a repudiation by the buyer before the time for delivery, that the seller will not have been able to deliver at the appointed time. So these two principles appear at first sight to conflict. I will just state, and then you can look at the case. So fortunately, the difficulty in stating the law was cleared up by the House of Lords in Cometol, SARL versus Mediterranean Shipping, COSA. I will put the case in the chat. And with that very brief expounding of the rule, I will go ahead and pass on the baton to Arike.
Thank you, Chelsea, and thank you to all the other group members. So this is our final part of the presentation where I present on the other rules. And for the sake of time, I will make it as brief as I possibly can. If I have case law to present on the rules, I'll just state the case law, and like Chelsea said, I will provide the case law in the group chat in case anyone needs to read further on the same. So we have presented that payment is concurrent with delivery. And so the next part is that delivery is supposed to be by the contracted quantity, so that if the seller delivers the wrong quantity, whether the seller delivers less or more, then the buyer has some power over whether or not they will accept. So section 31(1) says, where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject them. But if the buyer accepts the goods so delivered, he must pay for them at the contract rate. So that is pretty self-explanatory, where it's less than what was supposed to be delivered, then the buyer can just say that I am not accepting this. But if they accept, then whatever the contract rate was, so maybe they're buying at they're selling water bottles and they're buying at 30 shillings per bottle, and the seller delivered 5 less bottles that they were supposed to deliver, then the buyer will pay 300 less shillings than they were supposed to pay. So where the seller delivers more, again, the buyer may reject what has been delivered, or he may reject the whole thing. He may reject the excess amount. He may accept the whole thing, but then he again has to pay at contract rate. And then where there's a mixture of something, where the buyer ordered one thing and they got a delivery of a mixture of things, where something that they did not order, then the buyer has the right to only accept what they ordered or to reject the whole thing if they do not want to accept what they did not order together with what they ordered. Next, we have delivery by installments. So unless otherwise agreed, the buyer of the goods is not bound to accept the delivery of installments. So contractually, if we have agreed that I will deliver this by installments, then the buyer is contractually bound to accept them as such. But if we have not agreed that I will accept installments, then you bring me goods by installments, the buyer, me as the buyer, I can decide not to accept what you have told me, what you have brought to me. But there's a case which, again, I will send in the group chat, establishing that it is up to the court to decide if the whole thing now, if the whole contract will be severed, or if maybe the contract itself can be saved. Then we have another rule that says it says whether the breach of contract is a repudiation of the whole contract, or whether it's a severable breach giving rise to a claim for compensation but not a right to treat the whole contract as repudiated, is a question in each case. So it depends on the case. Then we have a delivery to a buyer's agent. This is where someone else other than the buyer, an authorized person, they can be expressly or impliedly authorized, as we have learned in the law of agency, accepts for the buyer. So in pursuance of a contract of sale, the seller is authorized or required to send the goods to the buyer. Delivery of the goods to the carrier, whether named by the buyer or not, for the purpose of transmission to the buyer, is prima facie deemed to be delivery of goods to the buyer. We have discussed this in terms of purchase, where it is to a respectable looking person. Then, unless otherwise authorized by the buyer, the seller must make such a contract with the carrier on behalf of the buyer as may be reasonable, having regard to the nature of the goods and other circumstances of the case. And if the seller omits to do so, and the goods are lost or damaged in the course of transit, the buyer may decline to treat the delivery to the carrier as a delivery to himself or may hold the seller responsible in damages. Unless otherwise agreed, where the goods are sent by the seller to the buyer by a route involving sea transit, under circumstances in which it is usual to insure, the seller must give such notice to the buyer as may enable him to insure them during their sea transit. And if the seller fails to do so, the goods shall be deemed to be at his risk during sea transit. Chelsea has already explained to us how the seller can be how the seller can have risk attached to him when goods are in transit. And here we are talking about if the goods are supposed to be insured. And the law is saying that the seller has to give notice to the buyer that these goods are supposed to be insured. Failure to do so, the risk shifts to the seller because they did not notify the buyer that they are supposed to insure their goods. And then where the seller agrees to deliver them at his own risk at a place other than where they are sold, the buyer must nevertheless, unless otherwise agreed, take any risk of deterioration in the goods necessary incident to the cost of transit. Again, here we are talking about transit and not just delivery. So where the seller of goods agrees to deliver them at his own risk at a place other than where where they were when sold, the buyer must nevertheless, unless otherwise agreed, take any risk. So it doesn't matter that the seller agreed to deliver them at his own risk. The risk of deterioration is to the buyer if the risk is necessarily incident to the cost of transit. So if they choose a transit that is unnecessarily long for the goods that are being moved from one place to another, then it is understood that the risk is on the buyer. And then where the goods are delivered to the buyer which he has not previously examined, he is not deemed to have accepted them unless and until he has had a reasonable opportunity of examining them for the purpose of ascertaining whether they are in conformity with the contract. So we have discussed this in previous lesson, where the buyer has the right to examine the goods and he or she should be given reasonable time. So the goods are not accepted until the buyer has had reasonable time to ascertain the goods, to examine the goods. And then unless otherwise agreed, where the seller tenders delivery of the goods to the buyer, he is bound on request to afford the buyer reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. So reasonable opportunity, reasonableness of the time afforded to examine the goods will depend in each case of the contract, so that the reasonable time to examine one thing is not necessarily the same reasonable time that is deemed to examine another thing. And then unless otherwise agreed, where goods are delivered to the buyer and he refuses to accept them, having the right to do so, he is not bound to return them to the seller, but it is sufficient if he intimates to the seller that he refuses to accept them. So two things are important here, that the buyer has to have a right to reject the goods. So maybe they are not the right quantity, maybe they are not in a deliverable state. For whatever reason, he has the right to reject the goods. He has to tell the seller that he refuses to accept the goods. And then as such, he is not bound to deliver the goods to the buyer. So the buyer is to organize to get the goods themselves. It is not the duty of the buyer to do that for them. And then where the seller is ready and willing to deliver the goods and requests the buyer to take delivery, and the buyer does not within a reasonable time after the request take delivery of the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery, and also for a reasonable charge for the care and custody of the goods, provided that nothing in this section shall affect the rights of the seller, where neglect or refusal of the buyer to take delivery of the goods to repudiation of the contract. So this is very simple to understand. We already said delivery is not dispatch. So the seller already has the goods, they are ready and willing to deliver the goods, and they tell the buyer that they're ready and willing to deliver the goods. Now it is up to the buyer to come and take the goods. if they do not do it within a reasonable time, then if the seller has to maybe pay money to store the goods or pay money to take care of these goods or any other loss, monetary or otherwise, that the seller will incur because the buyer did not take delivery of the goods, then the seller is liable to pay for those for that cost in whatever way that they're supposed to. So those are the rules of delivery, both the code that the Act has given and the rest that we found all over the Act. And now we will be taking questions. Thank you.
Thank you for this presentation. Any questions? Any questions from the class? We said unless otherwise agreed upon, a buyer is not bound to accept delivery by way of installments. Too much or less may entitle the buyer to reject the goods. What about if the disparity in terms of quantity is just minimal? Does it entitle a buyer to reject the goods in whole?
I will answer since you're the one who dealt with that part of the question. As we mentioned, the courts will deal with this. If it is very nominal, then no, it is not. The buyer will not be accepted to reject the contract as a whole. But it also depends on how much of an effect that will have on the whole contract. So it is dependent on now the actual facts of the case. But in most cases, if it is not very much affecting the contract and it is just something small, then I do not think that the whole contract will now be rejected.
Thank you, and that is correct, because we normally say the court does not deal with trivialities. The rule is normally expressed in Latin as de minimis non curat lex. Court of law does not deal with trivials or trivialities. Any question? And if there is no question, we can stop there. Excellent presentation. Now, you will send your presentations to my mail. Indicate clearly the members of each group and registration numbers. This will constitute cut 1. I will give you individual cut later. It will carry 10 marks only. The individual cut will carry 20 marks. Okay?
Thank you, sir.
But well done. So if there is no question from the members, we can stop there. We meet next Thursday.
Thank you.
Thank you. Bye-bye. Have a nice
Thank you,
afternoon.
sir.